Hope you're good. Hope you're fine. Hi. Hope you're doing well. Hope you're good. Welcome to Lawyers Info Hub. It's a pleasure to create content on this platform. This platform is born out of passion to reach out to law student lawyers, teach law, to bring the legal concepts into simplified form for ease of understanding and to help you in your practice and in your career as a lawyer. So today we're looking at understanding the mind of the court. Understanding the mind of the court. A diligent lawyer, a smart lawyer, is that lawyer that understands how the mind of the court works. Is that lawyer that understands how each of the courts, each of the judges, how their mind works. When you understand the mind of a court, understand the mind of the judge, it helps you, in your practice. It helps you in your matters. It helps you in how to approach the court. Now, as a legal practitioner and as a student, a law student who wants to be a lawyer, these things will not be taught in the law school. It's born out of experience. Your exposure in courts will teach you these things. And the experience they say is the best teacher, but it's I'm glad that someone who has experiences is talking to you. Now, if you don't understand the mind of the court, you might go to court and fall out with the judge. You might go to court and have a bad experience because you are going to that court not understanding how the court works, what works in the court, what are the do's and don'ts of the court. Each court have their own way of life, have their own way of operation. They have their own different modus operandi on how they function. So your ability to understand how this court functions is one of the things that will help you. You might have a beautiful case, you might have a wonderful, well-researched address, well-researched content, pleadings, but you keep on falling out of the procedure, out of the modus of the court. And the court begins to see you as a recalcitrant counsel. The court begins to see you as a counsel who has come to undermine, the powers of the court. And when the court begins to see you as that counsel or as that lawyer who is bent on disrespecting the court, then you don't expect to get have a good time in the court, even though it will not affect your matter. But when the court begins to see you as that counsel who is irresponsible, as that counsel who does things outside what the court has dictated or outside the modus of the court, or a lawyer who does things as they want, against the rules and the conditions or the court practice, the court, will have a very bad I will not call it mindset. It's got to have that feeling that this one is not a serious, and God will not give you all that attention you deserve. So, one of the first things you must understand as a counsel, as a practicing lawyer, as a lawyer who wants to go into practice, is that understanding the mind of the court helps you in your case. Now, one of the first things you look out for is that when you go to a court, when your matter is in a particular court, you first begin to observe the personality of the judge. When you understand the personality of the judge, is he a friendly judge? Is he a judge who is easily tempered? Is he a judge who the judges are very, very friendly that they even converse with counsel? Is he a judge that is a teacher? Is he a judge that is firm and does not take nonsense? Is he a judge that does not like counsels doing certain things in court? So you must learn the court. So understanding the court starts from you learning the court. When you've learned the court, you understand the modus of the court, you begin to practice in line with that you have learned. Now, there are courts that resume by 9 o'clock. And for whoever you are, 9, the court starts. And if you are that lawyer that doesn't come early, then you know that by the time one day you come to court, your matter has been called. There are courts that don't start early. It is a known fact because of maybe one or two things, maybe the distance or where they are situated. The court might want to start by 10 to allow counsels, coming or coming from wherever jurisdiction they're coming in. So depending on the location of the court, some courts are known to be 10 o'clock courts or courts that sit by 11 or courts that sit anytime. That's some judges, they don't have a specific line, they just sit anytime. They might sit early today, next week, they're not sitting early, next month, there are some courts like that. But if you know that this particular court, you know the timing of the court, this is an early in the court, this is a court that sits at night, this judge is a 9 o'clock judge, you have to be in court before time so that your matter will not have been called before you come in. There's some judges that don't like women wearing long earrings, flying their hair. There's some judges that they're not too petty, but they want it to be prim and proper. So if it's that judge that doesn't want, they always want to look at your beep, why they need to iron your beep, you're looking scruffy, why do you fly your hair as a woman, why didn't you pack it well? Some judges can walk you out, embarrass you in front of your client because of your dressing. Why are you wearing a blue suit? Why are you wearing an off black? There are courts that are so meticulous that even your dressing matters to them. So when you note that such judges are like that, so you have when you're appearing before them, you appear prim and proper, you appear well dressed, and you appear you know in line with what they want. Now there are courts that when you're appearing before them, you cannot bring in documents on that day. You just filed the process and you want to take it in. There are some courts that the registrars will not take it. They have a standing rule that you must bring your process 2 days before the hearing. So there are courts that have rules. Whereby some courts, even if you file it that day and you tell the court that, my lord, I just filed, and the court might be like, okay, can you bring it? Registrar collect it. Whereby there are some courts, no matter the urgency, if that process is not before them, they've not seen it, they will not they will not allow you to put it in the court on that day. They'll ask you to go and drop it. So you must understand these things. There are some courts that, as they're delivering a ruling, you are getting the certificate. If you bring your application, you can get the certified true copy that day. Whereby there are some courts that when the court delivers the ruling, it will take a while before the certified true copy can be made available to you. So when you understand the tactics of all the way a court moves, it helps. If you have matters before them, you plan things, you arrange yourself, plan things ahead of time. There are some courts that when you file any process, you must copy the court email. Yes, there are some processes that you file even a final written address, you must send a soft copy to the court, or you must put it in a flash drive. That there are some jurisdictions that have put it in their rules that for every final written address must have a soft copy in the flash drive, so that it will be easy for the court to have a soft copy and work with it rather than typing everything. For example, maybe in copying your summary of facts and all of those, it's easier for the court to just open it and copy and paste. There are some courts that simple applications are taken virtually. There are some applications, they don't need you to come. You once you come, they will just tell you, want this one court we hear virtually. There's some courts that have made things so easy for counsel. So you might not understand the mind of the court, you must understand how the court works. It's one of those things that help you have a smooth practice. But many people have failed to understand how the court works. Many people have failed to understand the personality of the judge they are appearing before. So you see counsels, exchanging words with judges, trying to prove a point. There are some judges, when they tell you something, they don't need to tell you twice. You just take the hint of the court and sit down. There's some judges that don't like that argument. They just want to tell you something, just take it. Whereby some judges want to hear your opinion. Okay, why do you think so? There are some judges you cannot appear before them without reading your file. You cannot appear before them without a file. They will even ask you, counsel, can I see your file? There are some judges that no matter how unopposed the application is, you have to move it. They don't do in terms. You can't move your application in terms. You must understand those things. But when you don't understand that, you now feel like, can't I just move this application in terms? There are some judges that when you announce appearance, you don't spell your name to them. They feel you're being insultive. Yes, when you call your name and you start spelling it, they'll ask you on whose authority. Did you say the leave of court? Did I ask you to spell the name? Don't you think just a mere appearance, you're already on the nerves of the judge. So it's very important that if you understand such judges, before you if you announce appearance and call your name. If the court doesn't get, the court will now by itself tell you, counsel, can you spell your surname? But if the court did not ask you to spell surname, it's so rude for you to start spelling. Some people will just make it so obvious, my lord. A for apple, P for peanuts, my lord. O for orange. Are you schooling? Are you in the school? Are you kidding me? So some judges don't like those jokes. Whereby some will just take it. You're just spelling your name. So you understanding these dynamics helps your practice. But when you just go into court and do anyhow, you come out anyhow, you might sometimes receive the shock of your life. So whenever you're appearing before any court, ask questions. Ask people around, go there on time, observe. You learn by observation. How does this court operate? Are there standing rules? There are some courts when your phone rings and they seize it, that is the end of the phone. Yes. And it's some before even the court starts, the registrar will say, please switch off your phone. If your phone is seized, you won't get it, or you get it after 1 month. There are some courts when they seize your phone, you have to do an application, then have to even defend the application before whoever you are, whether a counsel, whether a litigant, before your funds are being released to you. So such courts, you respect yourself. What about some courts, even when your phone rings, like, who is that? You can run out or off it and there's no problem. But there are decorum expected of a lawyer. And many judges, have ensured that in their courts, decorum, professionalism, punctuality, everything is in order. There's some courts that when your file jacket is torn, they will ask you, see, if you don't place this file, I'm not going to hear your matter again. There are some courts that hold their orders with high, like if they give cost, they don't even need the other counsel to remind the court that there was a cost. Once they start up, they say, cost, have you paid the cost? That's the first thing they say. So you must understand. So when you're appearing before such judges, you step up. If you need to pay a cost, you pay it fast. You don't need to delay. There are some costs that when they adjourn for trial and you scuttle the trial, you pay heavy costs. You pay costs for wasting the time of the court. You see courts awarding 200,000, 100,000 against counsel for, Scotland trial dates. So, geez, when you understand these things, it helps you because I've seen that most times many people come to court and get embarrassed, senior lawyers, because they don't know how the court works. They don't understand the mind of the court. So, when you understand the mind of the court, it's there for you to be a friend to the court. You see, some judges that people term very disciplined, they don't smile, they are very stiff, but they have counsels when they are prepared. They'll ask a counsel, which matter are you interested in? Even if it's a junior counsel, because they enjoy the person, they understand. There are some judges when you don't use the legal terms, when you don't use the language of the court, like, what did you just say? So you must understand and learn. And every day we go to court, you learn. You learn from other people how to use the right language. You don't use uncut languages. You know how to respond to the court, how to address the court. So these things are very, 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 very important. So understanding the mind of the court is one of the things a lawyer must learn. If you don't learn this, you end up having serious issues, and it might make your experiences not good enough for you to even encourage someone to join you. Even at the appellate court, you must know what to do, how to do it, how to address the court. If your matter is for appeal, is for the hearing of the appeal, how do you start? Many people don't know this. If your matter, you need to write your name on time before there are a lot of things to learn. Even if it's a magistrate court, how do I rope? How do I present? How which clothes can I wear and which clothes can I? I've seen where a magistrate walked out a counsel for those wearing, if it's a black attire, but there are touches of white and all that, the magistrate court. As much as you don't rope in the magistrate court, but you must dress well. So you must understand whereby some the magistrates, they've just turn a blind eye to what you're wearing. You fix your colored hair, they don't care. But some people, you don't try it. You don't, or you allow your wig, your bib to loosen up. You must button your jacket, or there are judges, magistrates, that are prim and proper. So understanding the mind of the court is one of the first step a lawyer who's a practicing lawyer must understand. Having a fruitful day in court involves a lot. You are beyond you knowing your matter, beyond you having good presentation. You must also learn how to play in line with the rules, the modus operandi of the court. If you're yet to subscribe to this channel, to this channel, hit the subscribe button. Consider subscribing to this channel. We have wonderful content. We have over 200 content on the channel. Wonderful, beautiful classes, interviews, discussions. Young, there are people who want to hear these things, who want to learn, and they are not even opportunities to know that things like this exist. Please share to your colleagues, share to your friends, share to your mentees, and share to your mentors. Tell them about Lawyers Info Hub. It's a pleasure that to create content. I consider myself privileged to share content to you. Thank you for always stopping by. My returning subscribers, I really appreciate you. God bless you. And for you who is yet to subscribe, please hit the subscribe button. Join the family. It's a wonderful family. We are here to ensure that you understand the nitty-gritties of law practice. Your practice, moves in a very beautiful pace, and you enjoy your career as a lawyer. Do take care of yourself. Bye.